Good morning to all of you. Welcome to Torts class. Friends, already we are discussing the vicarious liability of the state for the acts done by its employees. So, in non-sovereign functions, if it is sovereign function, state can happily say that it is a sovereign function, we need not pay any compensation. So in case of non-sovereign functions, state has to pay compensation. They can pay and recover from the concerned employee if any tort is proved. So this is the baseline. So in this vicarious liability, three cases particularly filed by women are most important, and if you are able to analyze these cases and explain the same in any of your torts class, you will definitely pass the examinations. So the first case is State of Rajasthan versus Vidyawati 1962. In this case, in the last video, we have discussed in detail that Vidyawati's husband was crashed in an accident done by or caused by Lokmal, the temporary or probationary driver of collector of Udaipur. Since the collector was not there in the jeep, it was held to be non-sovereign function. Therefore, the state has to be liable to pay compensation. Second example, best example for res ipsa loquitur. What is this res ipsa loquitur? This concept says thing speaks itself. Suppose if some incident takes place, you take a video, you make a photo, itself speaks volumes of anything. Is it not? Suppose if you file a case of tort, it is your duty to prove the same. For proving the same, you have to produce so many witnesses. Instead of witnesses, if you can produce the video copy or photocopy, then it will be sufficient. The judge will say, yeah, the thing itself is speaking. There is no other evidence needed. Come on, pay some compensation. This is the advantage of res ipsa loquitur. For this, Municipal Corporation of Delhi versus Subhagwanti 1966 case is very popular. Already I told you. So in this case, the tower clock near Chandni Chowk, which has to be maintained by the municipal authorities or Municipal Corporation of Delhi, it was not being maintained properly. Periodical checks have to be given. Of course, they have conducted check and they have written the reports, but no practical attendance was there. Ultimately, on the fateful day, it has come down. The towers, they have collapsed. Ultimately, the husband of Subhagwati and others, they died due to the accident. In this connection, yes, Municipal Corporation of Delhi, it was held liable, even though it is a sovereign function, since they failed to make repairs to the tower clock in time, and since they have passed the buck, since they have evaded their duty, yes, Municipal Corporation of Delhi has to pay compensation to the victim. Likewise, another case, Premwathi, State of Rajasthan. Premwathi versus State of Rajasthan, 1977. So, Vidyawati, State of Rajasthan versus Vidyawati, and this also Premwathi versus State of Rajasthan. So, State of Rajasthan versus Vidyawati is an appeal case. So, the government went up to the Supreme Court by taking a certificate under Article 133 of the Constitution of India. Of course, here, this Premwathi, she filed a case against the state of Rajasthan in the year 1977. This was disposed in the year 1977. So, better to know the facts of this case. Right, same jeep of the collector, it was coming from the garage and it was going to the bungalow of the collector. On the way, the driver gave lift to three unknown passengers. Of course, they were his friends. Three unknown passengers, and instead of going to the bungalow, he went on a spree. That means he went on joyride. Sardaga, వాళ్ళని వేసుకుని బండి బ్రర్రని తిప్పుతా ఉన్నాడు. Ultimately, an accident took place and 2 persons died. So, this is outside the employment of the so-called driver. Is it not? Actually, he is not supposed to give lift to the unknown persons. Collector garu jeep lo collector garu like vaalla manusulu like gumasta వాళ్ళు ఉండాలి, అంతేగాని how can he give lift to the other persons? Lift ఇచ్చాడు, ఇచ్చిన తర్వాత how can he go on a spree? వాడు ఇష్టం సాయంత్రం సరదా డ్రైవ్ లాగా వెళ్ళాడు. Ultimately, accident happened. Here, it is very clear case that the state is vicariously liable for the act done by the public servant because it is a non-sovereign function. So, going spree or taking the vehicle in a riding manner is outside the employment. Therefore, government is not liable. Who has to pay? Till such time, since sovereign function, normally you will be under the impression the government has to pay. Here, only the employee has to pay, even though it's a non-sovereign function. The government, because it is outside the employment, outside the reach of the employment. So he was not instructed. He was instructed not to allow any unauthorized passenger into the jeep. Right? Please remember, government need not pay any compensation. If you know these cases, it is sufficient. So with this, I am concluding. Thank you very much.